Hello and good evening. I'm Melisa Idris.
And I'm Sharaad Kuttan.
You're watching Consider This, the show where we want you to consider and then reconsider what you know of the news of the day. The federal court today struck down a provision of Selangor Sharia law that criminalizes, quote unquote, unnatural sex. Now, the 9-judge panel unanimously declared Section 28 of Selangor's Sharia criminal offences enactment as void for being unconstitutional, as it found that based on the federal constitution, the power to make such criminal laws fall under the parliament and not state legislature. The man who brought a legal challenge was among the 11 men arrested on suspicion of attempting sexual intercourse against the order of nature during a raid at a private residence. Joining us on the show tonight to help us understand what this ruling means and what it will change, we have constitutional expert, Emeritus Professor Datuk Dr. Shad Faruqi. Good evening, Prof. Shad. It's good to have you on the show. This was said to be a landmark decision. Now, can you help us begin the conversation with telling us what you understand to be the basis of the federal court's decision?
Thank you very much, Melisa and Sharaad. I'm indeed privileged to be with you on your program. Now, like you, I agree this is a landmark decision by our federal court. I think the name of the case is Iki Putra Mubarak versus Karajan Negeri Selangor. It's a great decision by a unanimous bench of 9 federal court judges. And I think the Chief Justice Tun Tengku Mamun Tuan Mat wrote a very learned opinion on behalf of her brother and sister judges. There is also a concurring judgment by Tan Sri Azhar. The judgment is a landmark decision, if I may use your words, because it affirms the supremacy of the Constitution. It affirms the federal-state division of power. So, you see, in our Constitution, we have a federal list of topics on which the federal parliament has exclusive power to make laws. Then we have a state list where the state assemblies, the 13 state assemblies, have power to make laws. More important, this decision illustrates the present court's willingness to handle touchy issues of the Sharia, which in many previous decisions in earlier decades were adroitly evaded or avoided, or sadly, I have to say that, guided by sentiment rather than by sound reasoning. This decision draws borderlines beyond which the state assemblies cannot punish crimes against the precepts of Islam. However, just to take half a minute to answer your question, I'm worried that too much is being read into the judgment. There is some over-optimism that the decision is implying that the Sharia courts cannot punish immorality, cannot punish sin, and cannot punish vice. The court did not say anything of that sort. The issue here basically was this: who has the power to punish homosexuality, federal or state? And the court said, as you correctly pointed out, Melisa, the court said the power belongs to the federal parliament, and that power already exists. The offence already exists in Section 377A of the Penal Code.
Professor Shad, there was a claim in the past that we had two systems of, two legal systems working in parallel harmoniously. And this suggests that this claim is no longer true. What we have is a clear sense of what dominates the Malaysian legal system and what is subordinate. Is that a correct reading? Has the Sharia legal system become subordinate to the larger and overarching federal and secular system?
You have a very good point here indeed, that actually in previous decades, some of our superior court judges were bending over backwards to expand the jurisdiction, both civil and criminal, of the Sharia courts, and to give to the Sharia courts a concurrent jurisdiction in crimes committed by Muslims. For example, in one of the very famous homosexuality cases, the courts were told that, the judges said there is a concurrent jurisdiction. The federal parliament can punish under section 377A carnal intercourse against the order of nature, and the states can punish liwat under Sharia law. Now, you are entirely correct here, Sharaad, that in this decision, the courts have firmly rejected that view. In the matter of criminal law, there cannot be concurrent jurisdiction. Either it must be punished in the federal courts or it must be punished in the Sharia courts. You cannot have two sets of trials or two sets of punishment. So in that respect, yes, you are right. However, I won't go so far as to say that the Sharia courts are now subordinate to the civil courts or to the federal courts in the matter of Islamic crimes. I'll be happy to elaborate on that later on.
Okay. But Professor Shad, just to follow up on that, if the federal court's decision today has concluded that under the Constitution, it is Parliament that has primacy over criminal law, would that mean then that hudud law cannot be implemented in Malaysia? Because, of course, hudud offences all include things like theft and robbery and murder, which are already under the penal code.
Sure. The federal court said that crime is in federal hands in general, and it does not matter whether the offense involved is also punishable in Islamic law. So as you correctly pointed out, Melisa, murder, theft, rape, robbery, treason, these are all Islamic offenses without doubt. But because crime is in federal hands, therefore these cannot be criminalized or punished by the Sharia courts. However, please bear this in mind, that in Schedule 9 is the schedule where there is federal-state division of power. In Schedule 9, it says very clearly the state assemblies can create and punish offenses against the precepts of Islam, except in regard to matters in the federal list. So I think those words are very important. They can create and punish, except in regard to matters in the federal list. These were the crucial words, except in regard to matters in the federal list. So the court emphasized that the state assemblies can punish Islamic offenses. For example, if someone denies the basic precepts of Islam, that can be punished. But the states cannot punish anything that is covered by the federal power over criminal law. Now coming to the issue of hudud offenses. Most of the hudud offenses, most of them, are actually already part of the criminal law within federal jurisdiction. And you're right, the states cannot punish hudud offenses, both in terms of what they can punish, what offense they can create or punish. They cannot do it because it's in the federal jurisdiction. And secondly, the penalty. The penalty for all Sharia offenses at the moment is governed by a federal law because the Constitution says so. The Constitution didn't want to give to the Sharia authorities and Sharia courts an unlimited power to create and punish and impose any penalty they like. The jurisdiction is 365. Some say 356. I say 365. 3 years imprisonment, 6 strokes of the rotan, and 5,000 ringgit fine. That's all that any Sharia offense can be punished with. So you're right, since hudud offences involve much greater penalties and much varied type of penalties, 100 strokes, death sentence, hudud offences cannot be punished by the Sharia authorities.
Professor, can you help us understand your concerns with regard to some of the headlines, sort of overreaching or overinterpreting this judgment in terms of larger political campaigns, that for personal liberty, for rights for sexual minorities and such? Why don't you think that this has an implication on those matters?
Now, I'm afraid the judgment did not in any way cover the issue of what you mentioned, rights of minorities, sexual minorities. The judgment did not in any way actually say that neither the federal government nor the state government can punish sins. It didn't say any of that sort. The basic issue in this case was this: who has the power to wield the rotan? If I may put it that way, federal or state? And the answer was federal. But whether punishing someone for buggery or punishing someone for carnal intercourse against the order of nature is a violation of fundamental rights to personal liberty or freedom of expression, that was not touched upon at all in this decision. So this decision is not about human rights. It's about federal-state division of power. Yes, sorry.
But in practical terms, in what is practiced in today, I'm just wondering, because what this means is that you're right, it doesn't decriminalize sexual intercourse against the order of nature, which includes same-sex sexual relations. There's still Section 377A of the Penal Code for that. But we know for a fact that not as many people have been charged under 377 as compared to the state Sharia enactment. So are you saying that perhaps, does this not clearly define that there could be a change in the way states impose or enforce certain policing against morality?
Yes, you have a very good point here. So what you are basically saying is this, that if one looks at the record, there are very few cases indeed on homosexuality, and therefore in actual practice what will mean is that the borders of freedom will now be broader. I agree with that. But I just wanted to point out that in our federal penal code, there is a large number of offences which could be regarded as violation of private morality. Obscenity, section 292 to 294, blasphemy, suicide, incest, buggery, carnal intercourse against the order of nature, sexual connection by object, polygamy for non-Muslims, enticing a married woman is a criminal offense under section 498. So the court said nothing about these offenses unconstitutional, not at all. But I agree with you. Much now depends on whether the law will be enforced vigorously or not. And you're right, the Sharia authorities in the states do enforce these private morality or private immorality laws vigorously, whereas the federal government does not. That is certainly true.
Okay, Professor Shah, what happens now? Is the implication not just for the state of Selangor and for all states within the Federation, all territories, including the Borneo territories? And also, what will the states have to do? Will they have to actively remove these enactments from their state law books in order to comply with this ruling?
I think that's an excellent question indeed, Sharaad. The courts have authoritatively pronounced that punishing carnal intercourse by whatever name, homosexuality, is outside the jurisdiction of the state assemblies. I think all state assemblies now must repeal that law. If they do not repeal it, then I think if they ever prosecute someone, the very first objection in the very first breath will be that they have no such jurisdiction because this law has been exterminated by this great decision in Iki Putra Mubarak case. So you're right. The states must go ahead and do it. If they do not and they prosecute, they'll probably end up paying heavy costs to the other side.
Right.
There'll be financial implications.
Professor Shad, thank you so much for joining us on the show. What a pleasure it's been speaking with you tonight. Thank you for your time.
Thank you very much. My great privilege.
We're going to take a quick break here on Consider This, but we will be back with more on this topic. Don't go anywhere. Stay tuned.
WFH. Siapa sangka 3 huruf ini banyak ubah hidup kita.
Bila sentuh soal berita, tiada masa untuk tunggu. Kepada anda kami bawakan fakta, susulan dan kupasan yang terkini. Tiada drama dan tiada pengulangan. Usah tunggu lama-lama. AWANI 7.45 lebih awal dari biasa.
Kini berwajah baru.
Ini pula susulan khas pesawat Back Air di Kazakhstan. Pesawat berkenaan dilaporkan tergelincir 2 kali.
Notifikasi berita terkini dan navigasi mudah. Podcast dikemas kini dengan berita dan program.
Rebirth, Reformasi, Resistance and Hope.
Serta video tanpa had dengan scroll tanpa henti. Buat turun aplikasi baru Astro AWANI sekarang.
Gagalan Kerajaan Persekutuan tunai janji melaksanakan projek baik pulih sekolah daif turut diulas Menteri Muda Pendidikan dan Penyelidikan Teknologi Dr. Anwar Rapai.
COVID-19, 2 lagi kes disyaki atau PUI direkodkan di Sarawak.
So hopefully kita akan mendapat kedudukan yang lebih baik di masa-masa akan datang.
Udang geragau atau bubuk dalam bahasa tempatan terkenal sebagai bahan utama dalam pembuatan belacan atau cencaluk.
Amanah di tangan kita. Adat, budaya dan semangat menjadi kesinambungan perpaduan tanah air yang tercinta.
Hi, you're watching Consider This. I'm Melisa Idris. With me is Sharaad Kuttan. Let's continue our conversation about the federal court's move to rule as invalid a section of Selangor's criminal offences enactment which criminalises sexual intercourse against the order of nature. What this means is that the courts have concluded that under the Constitution, it is Parliament that has primacy over criminal law. But will this prevent the state from interfering in questions of private morality? Thilaga is the founding member of the NGO Justice for Sisters, and she joins us on the line now. Thilaga, welcome to the show. Now, we understand that Justice for Sisters and other NGOs had supported the individual who brought this legal challenge. Now, I'm wondering, do you see the federal court ruling as a victory? Will this judgment provide any relief to the person who brought this legal challenge?
Hi, thank you so much for having me. I'm very happy to be here. Yeah, I definitely think that, the decision today is a victory for not just LGBT people, but everybody, right? I think the decision has different impacts on different groups. I think for LGBTIQ persons specifically, I think the decision is significant in 2 ways, right? One, of course, like the immediate relief that you talked about. So as for the 12 men, or rather the 7 men who pleaded not guilty, I guess we're expecting for the charges to be dropped because Section 28 no longer has any legal effect. So, immediately I think, the charges would be, we expect the charges to be dropped. And if we look at this law specifically, we have seen how, people who have pleaded guilty in the past have been subjected to, caning, imprisonment, and excessive, and, very excessive fines, almost maximum punishment under this law, right? So I think this definitely, and I also want to add that as a result of the prosecution of LGBT people under this law, it has caused a lot of trauma, and also, it's not just about the prosecution, but people have also resorted to self-harm because of the stress, and also been subjected to termination of jobs as well. So I think the impact is definitely big, and of course, the relief is also big, right? Because people are no longer living in fear, and also some level of trauma and anxiety has been lifted. At the same time,
if I could just interject, can I ask you that some have noted that the federal provision on unnatural sex, as they like to call it, is much harsher than the Sharia enactment sentences, right? So, and that somehow in this ruling, what you have for, at least for Muslim individuals, they no longer have a choice of the lesser punishment, following a jurisdiction with a lesser punishment. Is that ironic for you that this is kind of the consequence of the judgment?
Yeah, I think definitely, this is like an interesting conversation, right? Right immediately after the decision, we were flooded with this question, like, well, 377 is still there. Well, we have all these laws. So I just want to bring the focus back. Well, in Malaysia, there are at least 46 state Sharia laws that criminalize people based on sexual orientation, gender identity, and also consensual acts, right? So we are, and that is excluding the, Section 377. So we are living in a state of over-criminalization, right? So I think it's also quite interesting to see how the options that LGBT people have is to pick between this, these two, forms of criminalization, right? What are the lesser punishments that you want to have? And I don't think that's the kind of life that LGBT people deserve in this country. And I don't think that's the conversation where it should be. I think where we should move this conversation to is that, both laws criminalize LGBT people, and both laws have severe impact on our privacy, dignity, and also equality before the law. And also it opens us up for so much discrimination, right? So I think in this sense, and we've also seen many precedents and case laws in relation to Section 377. I would like to, a few years ago we had the landmark and very stunning decision from India, which sort of laid the framework for decriminalization, sort of strengthened it, right? So in this, I think both laws are problematic, and both laws need to be repealed, in time. And in this, I think even though, on the surface it does look like, yeah, of course, under 377 there's mandatory whipping, and the punishment for imprisonment is much higher. But at the same time, I think, the impact of both laws are still the same. If we look at the Terengganu case, which I was in court, I was in Terengganu observing this case, and I could see, even though, they said that the caning is not as bad as under 377, but the impact is still quite real, right? People still face severe humiliation and trauma, and have multiple forms of impact in terms of jobs, in terms of family, in terms of how they deal with their inner, their self-esteem and self-worth and all of those things. So I think in terms of impact, both of these laws have severe impact on LGBT people, and both of these laws have excessive punishment that actually, if we look at under international law, criminalizing people based on consensual private acts or sexual acts, or based on perceived or actual sexual orientation and gender identity, can amount to torture. So I think I just want to maybe leave it at that.
Thilaga, now that Section 28 has been ruled as invalid by the federal court, are you expecting, backlash either politically or socially to come out following this?
Yeah, for sure. I think, backlash and reprisals are always a huge consideration for LGBTIQ groups. I think that was one of the first things that we talked about, right? What are the backlash that we're going to deal with, and how are we going to deal with this? Can we deal with this? So I think some of the things that we are looking at are definitely, and even in fact today we talked about monitoring, the kind of backlash that folks will receive. And I think the backlash also has many layers. We also project or foresee termination of jobs, and not just prosecution under the state Islamic departments or the state agencies, but also by non-state actors, right? And this is something that Justice for Sisters has been documenting, and we are seeing a rise in discrimination by non-state actors. So we anticipate that, maybe there'll be hate crimes. Like recently we saw the jogger in Damansara who was sexually assaulted. And so we think that, we would be probably seeing more of these things. Hate crimes, termination, issues with rejection by family, people being disowned, and all of that.
Right. Thilaga, I want to ask you about what impact this has on the transgender community, often targeted, I think, using laws on cross-dressing, if I'm not mistaken, and often a very vulnerable population, often getting the short end of the stick when it comes to religious authorities. Is this going to have any impact? Will this provide protection for transgendered against this kind of persecution?
No, I think that's a really great question, and I think definitely this decision opens up the space for conversation around protection of LGBTIQ people across the board, right? And I agree, in this, transgender, non-binary, and gender non-conforming people are extremely vulnerable to violence by state actors and non-state actors, right? Because of their visibility, in terms of gender expression and gender identity. So we definitely see multiple forms of vulnerability for them. Again, similarly, like I said just now, they could be more vulnerable to hate crimes, termination, and also a lot more gender policing of the gender policing, right? And I think the other thing that I would like to add is that, when we look at these laws, especially in a binary context where trans people are not recognized for their gender identity and often perceived as their sex assigned at birth. These laws are used. These laws are also used against transgender people, right? So, for example, Justice for Sisters has assisted at least 4 transgender women who were persecuted under liwat or sex against the order of nature. So I think it's not useful to compartmentalize these laws, as these laws are for gay people and these laws are for trans people. But also seeing this within this context of gender binary, and seeing that these laws actually have trans people are actually subjected to multiple forms of criminalization because of this binary that we are in. But of course, yes, sorry.
Well, unfortunately, we've run out of time, and I do want to thank you so much for joining us on the show. We appreciate you sharing your insights with us tonight. Thank you.
Thank you.
That's all we have for you on this episode of Consider This. Don't forget to get all the latest news and info on COVID-19 vaccines on astroawani.com and the Astro Awani app. Thank you so much for watching. I'm Melisa Idris.
And I'm Sharaad Kuttan signing off for the evening.
Thank you so much.